Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. The excitement around the result of the Ripple versus SEC litigation has reached fever pitch. Several members of the XRP community had counted on pro-XRP lawyer James K. Filon's forecast that Judge Annalisa Torres' judgment would arrive before the end of March. Unfortunately, his prognosis did not come true, leaving XRP investors perplexed, with many XRP fans wondering why Judge Torres didn't rule yesterday. Crypto law founding attorney John Deaton identified the few insiders who may know the precise date of the judgment. According to Deaton, only Judge Torres' staff and the court clerk would be aware of the Ripple V's SEC judgment date. The only individuals who will know before the judge publicly publishes her verdict are her staff and any clerks who assisted her with research or decision-making, Deaton added. His most recent statement is in reaction to XRP aficionados who think Ripple and SEC executives will be aware of the date. It's worth noting that Deaton's statement came only hours after he anticipated that Judge Torres' decision may take up to 60 days. Notably, numerous XRP supporters were disappointed when Judge Torres did not make a judgment yesterday, March 31, as Filon projected. In response to a remark on the matter, Deaton explained that the deadline for Judge Torres to grant summary judgment was not yesterday. He indicated that Judge Torres might rule within the hour or opt to disclose the decision during the following 2 months. According to Deaton's past cases, Judge Torres normally gives summary judgment a few months after evaluating Daubert's motions. It is worth noting that Deaton is heavily engaged in the litigation, acting as an amicus curiae for members of the XRP community, friend of the court. Deaton expects that, as amici curiae, Judge Torres will rule in favor of XRP holders by finding that the coin's secondary market transactions do not constitute a security. Deaton listed 4 potential litigation outcomes that might benefit XRP investors yesterday. Deaton believes that Judge Torres will decide that XRP secondary market transactions are not securities in all 4 scenarios. But if Judge Torres awards a summary judgment in favor of the SEC and fails to remark on XRP, Deaton said he would try to get the court to define the crypto asset, as he did in the Learbry case. Recently, some members of the XRP community have asked on Twitter why Judge Annalisa Torres has not yet rendered her decision in the case between Ripple and the SEC. Many Ripple and XRP supporters anticipated the judge's decision would come before the end of the previous month, as predicted by pro-XRP attorney James Filon. This wasn't the case, however, which raised concerns about the delay's potential reason. Attorney John Deaton, the creator of crypto law, outlined the reasons behind Judge Torres' delay in rendering a decision on the lawsuit's summary judgment in a video clip that has been making the rounds in the XRP community. Judge Torres, according to lawyer Deaton, is taking her time to make sure she makes the proper decision because she is aware of the importance of the action. He questioned if Judge Torres had ever experienced the kind of pressure she has in the Ripple litigation, particularly from the blockchain business, during her whole tenure. I sincerely doubt Judge Torres has ever experienced the stress she is now going through. Judge, Ripple is sending look at what the Voyager judge stated, what the Supreme Court said about fair notice, the SEC's actions, Binance, and the CFI's actions, Binance, and the CEFTES, among other things. Deaton was cited as adding. He clarified that these events are taking place at a time when he and many other people claimed that her ruling in the litigation will provide the U.S. crypto market with regulatory certainty. He emphasized that since 1946, the time of the Howey case, the pending Ripple v. SEC complaint is the most major non-fraud SEC enforcement action. Deaton continued by saying he does not hold Judge Torres responsible for the speed at which she formulates her ruling. Deaton claims that Judge Torres is under a lot of pressure since she is aware that if she rules against Ripple, the blockchain corporation would file an appeal with a higher court. He noted that the judge must provide an explanation of her reasoning if she awards summary judgment to Ripple. So, he added, I don't blame Judge Torres for being extremely cautious about how she works on this judgment because if it goes against Ripple, she knows it's going to a conservative court, and if it is for Ripple, she has to defend it. Attorney Deaton also asked the XRP community to be patient, since the decision is not as straightforward as many believe. Days prior to his most recent statement, Deaton said that Judge Torres may take as long as 2 months to make a decision about the complaint. Thousands of XRP holders are represented in the lawsuit by Deaton as an amici curia, friend of the court, and she claims that Judge Torres' summary judgment decision often follows her decision on the Daubert motions by a few months. Deaton said on March 31 that the decision might take up to 60 days in light of this. Brad Garlinghouse, the CEO of Ripple Labs, has attacked the chairman of the U.S., Gary Gensler of the Securities and Exchange Commission, SEC, for determining whether crypto tokens are securities. On Thursday, Garlinghouse tweeted, "It defies logic for the SEC chair to say that he determines what constitutes a security, rather than the statute from which his agency obtains its authority. It is past time for elected authorities in the United States to take notice." Why would you ever want to offer clarity about what's in or out when you act like an authoritarian overseeing a $2 2-cents be bloated agency? When there is no clear jurisdiction, uncertainty masquerades as authority, Garlinghouse said. The Ripple executive made the statement in response to Gensler's claim that current securities laws cover most of the activity that's going on in the crypto markets. Gensler was quoted as saying, "If Congress were to act, though I don't think we need these authorities not to undermine inadvertently through definitions of what's in or out, or in essence, allowing for conflicts that we don't allow. Several of the legislative vehicles, in my opinion, would weaken the securities remit if they were implemented." Since December 2020, when the SEC filed a complaint against Ripple, Garlinghouse, and co-founder Chris Larson, the business has been involved in a legal battle with the securities regulator. The SEC declared XRP to be a security, although Ripple and Garlinghouse have continually denied this. Gensler has underlined the need of Bitcoin exchanges and lending platforms coming in to discuss how to comply with the SEC on multiple occasions. Garlinghouse, on the other hand, has accused the SEC of engaging with crypto businesses simply to generate leads for its enforcement division. There have also been persistent accusations that the SEC lacks clear regulatory rules, making it difficult for crypto firms to assure compliance. The SEC has issued a Wells notice to the NASDAQ-listed cryptocurrency exchange Coinbase investigating alleged securities law breaches. In its reaction, the business said the SEC will not allow crypto companies come in and register. "We tried." However, Gensler has consistently stated that, with the exception of Bitcoin, all crypto tokens are considered securities.